Well, good morning, and thank you for the very kind introduction, but I would like particularly to thank the organisers of this conference. It's a particular pleasure for me that the Central European Academy is based in Miskolc, because many years ago I worked a lot at Miskolc and visited many times. But it's also particularly nice for me that it's the Ferenc Mádl Institute, because I had the privilege of getting to know Professor Mádl and working with him. He was a great man, but also a very kind and charming man. And I have to say, I miss his company very much. It's also wonderful to be able to celebrate the 10th anniversary of the Hungarian Civil Code. And I think that, I should say, I'm a great admirer of civil codes. And I think that Professor Vékás's work and the work of all the people who were involved in the project was absolutely marvelous, and they are all to be congratulated. And indeed, civil codes in principle are a wonderful thing. We've seen many of the advantages already talked about. The system should be complete and coherent and logical in an accessible form to give ready guidance to courts and practitioners, so that in principle at least they should be able to deduce the answers to the problem that they're faced with by looking at the text of the code. Now, of course, as Professor Ményhard said last night, actually a great deal of creativity is involved, as I understand it. I view it from the outside, of course, particularly when a judge has to apply a very broad, open-textured text, really not so much a rule as a standard, and also, of course, when they have to fall back on the general clauses in order to deal with problems that the code hasn't confronted at all. And lastly, hopefully, a code is going to be understandable, at least by some of the citizens who are subject to it. And certainly, as I understand it, the Code Napoleon was intended as guidance for the behavior of citizens when doing business. Now, I come from a very different system because, as you all know, in the common law, nearly all are private law, at least as far as general contract law is concerned, also tort or civil responsibility and unjust enrichment. It's nearly all judge-made law. It's based on case law which has developed over many years, hundreds of years in some cases. It's not always been consistent. We've, of course, had periods when different courts have laid down different rules. In particular, we had this divide between what the common law courts did and what the Chancellor did in the Court of Equity. Hopefully, that clash was resolved to some extent in the 19th century by the Judicature Acts, which said that any court will administer both sets of rules, but, sorry, I've gone too pressed my button by mistake, the rules of equity would always prevail. But that doesn't mean that our legal thinking has caught up. We still ask, what's the position at common law? What's the position in equity? And our process of reasoning is different, because before we can start deducing the answer from what we think the law to be, we have to induce from all the cases what the law is. It's a process of trying to read the cases and work out what has been decided before. And what a judge will do is to look for previous authority to decide whether it's relevant. But of course, a previous case is only relevant if the facts are the same. If they are distinguishable, then the authority may not be very much help at all. And as you know, right from the word go, the emphasis of the common law has not been about applying principles. It's about solving the particular dispute which is confronting the court. And we tend to be very much more pragmatic than we are principled. And our legal development tends to be one step at a time, incremental. And particularly courts are very reluctant to decide more than is absolutely essential for the case in hand. They will often say, there is a bigger question here, but we leave that for another day. And they're also very reluctant to adopt general principles, particularly in contract law. Many of you may be familiar with this quotation from Lord Justice Bingham in a case called Interphoto. Bingham was one of the few English judges who actually knew a relatively large amount of civil law. And he contrasted the good faith principle that is found in most civil law systems with English law, and said English law has characteristically committed itself to no overriding principle, but has developed piecemeal solutions in response to demonstrated problems of unfairness. Now, he was talking about unfairness in that context, but I think it's generally true. We tend to have piecemeal solutions. And it's certainly the case that our private law has never been reviewed as a whole. And sometimes there are bits of it which simply contradict each other. They seem to go in opposite directions in terms of policy. And as to being in logical order, well, somebody once said the last time that English law was in logical order was in the late 17th, early 18th centuries, when lawyers produced what they call abridgments, which simply set out the law topic by topic in alphabetical order, starting with advowsons and ending up with waste. And that's the closest we've ever got to logic in English law. And of course, our law is only really accessible to lawyers. People like me can write textbooks to try to explain it to other people, but basically you have to be a lawyer to understand it. Now, we of course do have legislation, but particularly in the areas of general contract law, tort or unjust enrichment, that tends to be simply because some topic needed reform, and the legislation is very specific. The Contracts, Rights of Third Parties Act, which enabled us to create third-party beneficiaries. In tort, the Occupiers Liability Act. In unjust enrichment, what we call the Frustrated Contracts Act of 1943. But again, remember that the English interpretation of legislation is very different to that in some continental countries. English judges tend to interpret statutes, legislation, as if they were intrusions on the common law. And the law is only changed so far as the statute either expressly or by necessary implication says. And we certainly don't do what has happened in France, that the courts and doctrine have used statute as a guide to an analogical development. That's not acceptable in England, at least according to most judges. Now, perhaps under the influence of Jeremy Bentham, who wanted the law to be restated in the code, during the 19th century, there were a number of what we call codifications. That is, attempts to restate law that had become a confusing mass of cases. For example, the Bills of Exchange Act, the Partnership Act, and particularly the Sale of Goods Act. But these are not codes in your sense, and they're not even US-style restatements. They're not codes because they're incomplete. They explicitly say this must be supplemented by the rules of common law and equity, so it's just a partial statement of the law. And it's not like a restatement because those statutes are interpreted strictly, just like the statutes I mentioned before. You read the statute, and you don't use it to develop the law. Now, during this century, of course, and the last century, there have been a number of major legislative projects, so that actually much of our law of property is contained in a series of statutes. Our family law is contained largely in a series of statutes, but again, they are not complete. During the most recent years, we've had a number of attempts to make the law more accessible, particularly to consumers. So one example was the Supply of Goods and Services Act, 1982, though that actually no longer applies to consumers because now we have something called the Consumer Rights Act, which tries to set out the consumer's rights when goods or digital content or services have been supplied and they don't conform to the contract. It also deals with unfair contract terms. But again, it's still incomplete. Many topics, even in consumer contracts, are governed by the Sale of Goods Act, and the Sale of Goods Act doesn't give you all the answers either, so you have to go back to common law. And of course, the Consumer Rights Act doesn't apply to businesses, so some small business that buys digital content and finds it's defective will have to go back to the common law on digital content. Well, strangely enough, we don't have much common law on digital content, so exactly what that means, we really don't know. Now, there has been interest in codification. Many of you will know that in the 1960s, permanent law commissions, that is, law reform agencies, were set up, one for England and Wales and one for Scotland. And in the early years, there was a joint project to codify contract law. And Professor Harvey McGregor actually produced a contract code for the Law Commission, the sort of first draft. For many years, it remained secret. The Law Commission, because it was a government body, felt it had to observe secrecy. And when I first went to work there, I was required to sign a declaration that I would comply with the Official Secrets Act. And I've still got some documents which I'm a little bit afraid to reveal. But if you can now find this code because Professor Gandolfi in Italy actually published it, and now it's freely available. And if you look at it, it does look like a civil code. It's very similar in style to the Peckle or the Univar principles. But that project was abandoned in 1972. Why was it abandoned? Well, one problem was that there were lots of arguments between the English and the Scots over terminology and so on. So, for example, the English wanted to get rid of our doctrine of consideration, which most English lawyers think is a complete waste of space, and just have the German system that if a contract was intended to be binding and the other parties agreed, you've got a contract. But the Scots said, oh no, we want that result, but you can't call it a contract. It must be called a policitation. And, you know, they just got head-to-head arguments over that sort of thing. But the biggest problem came when it came to the detailed drafting. Because we have this breed of lawyer in England called parliamentary draftsmen who draft the legislation that goes before Parliament. And we've heard about this yesterday. The English approach is to try to make the legislation judge-proof. Because you know that it's going to be interpreted strictly, just by the letter, you have to try to work out how it's going to apply in lots of different situations, and then spell that out in the legislation. Parliamentary Council's idea is that you should be able to answer every conceivable question without having to take your eyes off the paper. Just read the statute. What happened? Well, Harvey McGregor would produce 2 paragraphs, and these are the secret documents that I've got. The equivalent is 8 pages of stuff that just goes on and on and on. And basically, the project fell apart. One of my Scots colleagues told me because the Scots wanted a code, but the English wanted a statute, and the two things are just completely different. But also, there was a just total lack of professional interest, and the same applied in this century, where Professor Sir Roy Good argued very strongly that we should have a commercial code. Practitioners, judges, just not interested. It's very much the same reasoning you get with the question of whether we should adopt the Vienna Convention on International Sales. The profession said, why? What's the point? We've got perfectly good English law. Thank you very much. Go away. So I guess the problem is that, well, my dear friend Professor Reiner said yesterday, if you don't have a code, you don't have a legal culture. So I think I'm the barbarian at the gate. But the question is, how do we manage? Why do we have no enthusiasm for a civil code in England? Particularly when English law prides itself on being certain. Isn't the common law, where the law is made by the judges, a recipe for uncertainty? Well, you might think that England was a relatively rational, moderate country, at least we thought that until a certain fateful day in 2016 when we went crazy and left the EU. But we've managed somehow. So how do we do it? Well, I want to take the two questions together, and I think there are several possible answers. But let me just make the obvious point that one thing that's not happened with us, we have not had any political reason for adopting a civil code. Because, of course, the last time we had a major political revolution was in the 17th century, before the modern codification movement started, as it were. So that gets that out of the way. Well, firstly, of course, the courts do enunciate general principles. Many of you will be familiar with our law of tort and the famous case of Donoghue and Stevenson. It's actually a Scottish case. All the best tort cases are Scottish for some reason. And Lord Atkin, in that case, did lay down a very general principle he called the neighbour principle. And it's now accepted that that principle means that you have a duty to take care to avoid causing personal injury or property damage to anyone else. That's a basic law rule of the law of tort. But it doesn't extend to purely financial or economic loss. In order to recover that, you'd have to show that the other party undertook responsibility towards you or that you were in some kind of close relationship. And of course, academics lay down general principles. Now, again, be very careful. English law is quite different to, say, French law, where doctrine is an established source of law. We have nothing equivalent. Textbooks have no formal status. And indeed, until the 1980s, textbooks were very seldom cited by judges in court. Indeed, when I was a student, I was taught you may not cite a textbook unless the author is dead, because if they're still alive, he or she might change their mind, and therefore the court would be misled. Well, now textbooks are cited, but they're still not a formal source of authority. Usually they're cited just because they provide a convenient summary, and the courts have absolutely no hesitation in saying that this textbook is simply wrong, as I've discovered to my cost quite a number of times. But textbooks nonetheless have sometimes developed principles which the courts have adopted wholesale. The best example, I think, is our law of restitution. Until the textbook of Goff and Jones on restitution was published, we really couldn't say that we had a law of restitution. Now it has developed very strongly, particularly with the work of Professor Peter Birks. But of course, the next point to remind you of, you will all know this, is that we do have a strict doctrine of precedent, and it's much stricter than the sort of jurisprudence constante that you find, say, in France. We have a strict hierarchy where the higher court's decisions are binding on the lower courts. The Supreme Court, formerly known as the House of Lords, can reverse its own decisions, but the Court of Appeal cannot do so except in exceptional circumstances. In the High Court, one High Court judge is not bound to follow what a previous High Court judge has decided, but you would, I think, be expected to explain why you're not doing so and give very detailed reasons as to why you think that you should not follow a previous decision of another High Court judge. So it's quite a tight system, and decisions from the lower courts are not lawmaking and they're very seldom reported. We just ignore them. Of course, they are subject to appeal. If they get up to an appeal, then the law will be laid down, but they don't make law themselves. And I think all this is helped by the fact that we actually have a very small number of judges in our superior courts. We're talking of only just over 100. The Court of Appeal, and we have a single Court of Appeal. It's not like France where you have regional courts of appeal. We have a single Court of Appeal which only has 40 members, which is a major problem, I have to say. They keep having to bring people out of retirement because they've got too many cases to deal with. And our Supreme Court is only 12 people. So it's a very tight-knit community of judges, particularly as most of them were senior barristers. We now have one academic who went to the Supreme Court, and we've got a number of solicitors who've become judges, but most of them were senior barristers. So again, they all know each other, and most advocates are barristers. Again, a relatively small number of barristers. They all have to be socialized by becoming a member of an Inn of Court. They're subject to quite strict professional regulation, but also they owe duties to a court. So, for example, if I know that there is a case which goes against my argument, I have a professional duty and a duty owed to the court to tell the judge about it. And I think that keeps everything quite tight and together, so that that's how we don't, as it were, lose control, despite the fact that in principle, judges can develop the law. I also would add that it's still the case that most of our procedure is oral. Advocates do now have to submit a skeleton argument in writing before they start, but basically it's still oral hearings. Again, a very different system to most continental ones. So, as I say, the law develops incrementally, and we prefer particular rules to broad standards. And English judges are particularly fond of saying we don't want a broad standard because then we won't know how it will be applied in the future. We want something that is predictable. Now, of course, every now and again, there are major reversals of direction. For example, about recovery of economic loss in tort. There was a case in 1978 which said that generally speaking, the Lord Atkins neighbour principle, if you can foresee loss, you have a duty to avoid it, applied equally to financial loss. But in 1990, that was reversed, and they said, no, financial loss is not normally going to be recoverable in tort. But very often, because the profession is tight-knit, they will be able to anticipate that this change might happen. And very frequently, they will be advising clients, this seems to be the law at the moment, but we noticed that there are a number of judges who are unhappy about this, and you can expect a change. You should factor that into the risks. And we tend to be pragmatic, and I'd like to illustrate that just with one example from what we call the swimming pool cases. Two cases, one French and one English. In the French case, a swimming pool was supposed to be built with 4 steps leading down into the water. By mistake, I guess, it was built with only 3. And the question was whether the court could order that the pool be rebuilt, despite the fact that it was perfectly good for swimming in. And the Cour de Cassation said, yes, it's perfectly proper to order that the pool be rebuilt. The English case is called Ruxley and Forsyth, and it was about a swimming pool which was dug to a shallower depth than had been contracted for. It was only the standard depth of 1.8 metres instead of the contracted for depth of 2.2. But it was perfectly good for swimming in. Now, we don't give specific performance in cases like that, or we didn't at this time. And the question was, how would you calculate the damages? Should the damages be enough to completely rebuild the pool or not? And the House of Lords said it would be completely pointless to rebuild the pool. It's a perfectly satisfactory pool. You're not getting anything except any difference in value, which is nil, and we'll give you a little bit of compensation, token amount, for what we call loss of amenity. So you can see how pragmatic we are. And many French lawyers, until 2016, would have said that that is unprincipled, I think. Of course, in 2016, they adopted a test, a restriction on enforcement, that it must not be disproportionate to the benefit to the creditor, and it may well be that the outcome would be different in French law now. The next point is that, of course, English judges go in for very detailed consideration of the facts, because the facts will determine the outcome. It's very much fact-orientated, and English judgments are painfully long to read because the judges go into so much detail on the facts. But they also can take into account things which you wouldn't find in the Civil Code. Policy factors, which are, as it were, extraneous, but nonetheless relevant. So, for example, one of the reasons why the House of Lords went back on its decision in Anns and the London Borough of Merton was that it was realised that this was being used to make local authorities liable, and the cost was therefore falling on the taxpayer, whereas the judges thought it should fall on private individuals. And you equally find arguments in tort cases that this would impose an impossible burden on the National Health Service, so we're going to deny recovery. That sort of policy consideration can be taken into account. Is reform any easier? Well, legislation on a specific point, pointillist legislation, is certainly easier to achieve than a new civil code. Judicial reform, well, we've had some reforming judges, particularly Lord Denning, but other judges have said, no, really, reform is a matter for legislation, especially, I think, when it's going to restrict freedom of contract. They say that should be left to Parliament, judges shouldn't do it. They do seem to be slightly happier when what they think they're doing is going to make life easier for business. And occasionally we have had some quite revolutionary decisions, I think. I'm just going to mention one, the case of Barclays Bank and O'Brien. After the Thatcher era, there was a great emphasis on small businesses starting up. If you're going to start up a small business, you need credit. You want to borrow it from the bank's going to look for security. What kind of security could a business person offer? Well, that period coincided with a rise in the value of houses. So in many cases, the bank said, we want to take a charge over the matrimonial home, a mortgage, a hypothec over the matrimonial home, as a guarantee. The problem for the husband, typically, was that the wife was co-owner. So the wife had to sign. And I'm afraid there were a number of English husbands who used undue influence or duress or misrepresentation to get their wife to agree to charge the matrimonial home. And I use husband and wife deliberately because most of the cases involved a business being set up by the husband using the wife's share of the matrimonial home as part of the security. My colleague in Australia called it the problem of sexually transmitted debt, which I think is a nice one. And what the House of Lords said was, a bank lending to a husband when there's no obvious benefit to the wife because she's not a co-owner of the business, there's always a risk that there's going to be undue influence. And if the bank doesn't check that the wife has decided this freely, the bank is going to be treated as knowing about any undue influence that the husband has exercised, and they will therefore be unable to enforce the charge. And that introduced a new system which, in a sense, made it much safer and therefore easier for people to use their houses as security for businesses. But I think you always have to remember the commercial nature of English law. English judges have an inherent power to develop the law. They don't need to fall back on a general clause. After all, they are representatives of the Crown, and they have the power to rule. But actually, we have developed far fewer controls over contractual behaviour than most civilian systems. Think of some of the key differences between the common law systems and the systems that you're used to. We have no liability for breaking off negotiations at the last moment. We have very few controls over unfair terms in business-to-business contracts. We don't give relief on the ground of mistake. We don't have fraud by non-disclosure. We don't have any duties of disclosure outside insurance and one or two other contracts. We don't use specific performance. We don't allow adjustment for change of circumstances. Our law looks very different. And I think there are all sorts of reasons for that. One is that English law is not an academic product. It's produced by judges deciding real things and trying to decide only what they need to decide. It's not intended as a guide to behaviour. It's intended to resolve the particular dispute. The judges will say it's up to the parties to work out next time how they want to deal with this. And I think that attitude, and I've argued this elsewhere, actually before in Budapest, that this is because of the typical cases that we see in our courts. It seems to me that part of the reason why a particular country adopts a particular style, particularly substance, of their law of contract, at any rate, is because of the type of case that they envision coming before the courts. And if you think about our English lawmaking courts, the superior courts, they're populated almost entirely by business people making large, valuable commercial contracts, because litigation in England is so expensive that nobody will litigate a small contract. Those people usually had legal advice, or else they were what we call repeat players, people who've been making the same kind of contract for years and years and know what they're doing. Those people don't need protection. And you'll also know that English law tries to sell itself as the law of choice for transnational contracts. And it's always taken the view that what international business people want is freedom of contract. So that even those very limited controls we have over unfair terms in business-to-business contracts, they're written in the Unfair Contract Terms Act 1977, do not apply to international contracts or contracts which are only subject to English law because the parties have chosen it. But I think the biggest problem is professional conservatism. But when I was at the Law Commission and we worked on a number of things, including controls over unfair terms, but also security interests, we found that particularly the large firms of solicitors were very, very resistant to change. It's not just habit, path dependency. It's not just the fear of losing business to New York. The biggest thing is they have a vested interest in the present system because only lawyers can understand it. They have precedents that work around the law or deal with the problems. They have the know-how, and they want to preserve it. So don't look to England for any codification. We're going to float off into the Atlantic as happy barbarians. But thank you very much.